So I've put a question mark in the title because when we started the research, we still had the idea that there was something like an EU legal framework for big data analytics in the health sector, but it's more, of course, and it's after our conclusion no, and it's more or less evident is that it is something that we strive for, that we are underway to, and I leave it to you to make up your mind after my presentation about how far we are in this trajectory towards a EU legal framework. So we did this research in the framework of AEGLE, together with my collaborator Maho, who is also present here. We are both working for Timelex. Timelex is a law firm in Brussels specialized in IT-related legal issues. It's not very common for law firms to participate in Horizon 2020 actions. Most lawyers are busy with much more lucrative businesses than European projects, but the reason is probably that myself and also many of our partners are former academics. I was a law professor for my whole career before, and I was in charge of a research team of more than 30 people working continuously on European projects, more than 100 European projects we have been involved in, starting from FP5, FP6, FP7. And we have a little bit continued this work under in a much more professional way in the framework of the law firm. We do also a lot of policy support work for the European Commission under a framework contract with DG Just. We are assisting the European Commission in the implementation of the GDPR, for instance, adequacy studies, and also in the health sector, for instance. So, and also on the national level, we, besides being a normal law firm, we do a lot of policy support and also research. So in the context of AEGLE, the legal problem we were facing was that the data came from 4 countries, and the ambition was to put them together on a common cloud platform and then perform big data analytics on it. And so if you collect data from 4 European countries, of course the initial question is it legally permitted to use these data for under the existing law, which when AEGLE started was still the 1995 directive and the implementing national legislations. So data came in you probably have already heard this during the conference from the UK, Sweden, Italy, and Greece. And our first finding was that it is not very easy to find the answer straight away. Even on the national level, for most of the countries, there is no comprehensive legal information ready, like in a manual or where you can find which are the legal rules that a researcher needs to respect in order to collect health data for research purposes. The answer was very different. I will not go into the details of it, but for instance, in Italy, you have a system which is in the form of a more general authorization, and you have to fulfill all the conditions of this general authorization. It's a general authorization from the Garante, the data protection authority in Italy. But for Greece, we had to apply for individual authorizations from the data protection authority with specific procedure, etc., etc. And also for Sweden and UK, the rules are very divergent. In particular, like in the case of Greece, the ICU case, where the ambition was to reuse data without informed consent, and the data have not been collected initially on the basis of an informed consent of the patient. That makes the procedures in most cases a little bit more complex. And so the question then, when we had solved, let's say, the legal issue in the context of the AEGLE project itself, for the 4 countries and for the data specifically needed for the AEGLE innovation action, of course, within the budget that we received, which was quite substantial, I must recognize it, our ambition must go further, and so the question that we tackled then was, what if you do the same as what we did in AEGLE, but with all the countries together? So if someone wants to perform big data analytics European-wide, with data coming from all the European countries, what would then be the legal challenge? Which rules, can we bring these rules together? And that's what we have done. We could do this, of course, to a certain extent, because while we were working under the AEGLE action, the legal framework at the European level was changing. You know that the GDPR proposal from the Commission came out in 2012, but until next week, Friday next week, we are still under the regime of the 1995 directive. But at the same time, of course, we had to take into account that the last months of the AEGLE innovation action, we will be under the application of the GDPR. So it was, let's say, one of the main challenges was to take into account this moving legal picture because of the GDPR. AEGLE allowed us to collect answers from 30 countries. So we did the 28 European member states and also Norway and Switzerland. And we did that on the basis of national experts. So we contacted a network on, well, it's a network that we don't use for the first time, but which we adapt also a little bit depending on the context. And we approached these legal experts in all the member states with a questionnaire and a model report, which Maho did for France. So we start with a model report, and then we asked our national correspondents to do the same for all these other countries, which is not very obvious to do under an Horizon 2020 action. And there, I must say, we are very, very grateful that our project officer, Sailarina, was very understanding, also gave us the trust needed to do that, because she was very, very flexible in interpreting the rules, and which made it possible to work with a large number of experts in all these countries and ask them to write a report on what are the legal rules in your country if you want to use or reuse health data for research purposes. Okay, so lots of reports that we collected, in which you can find some of these reports 20 pages, some 50, 60 pages, in which you can find what is the current status of the law, which rules do you have to respect today, and how will they change little by little, probably, with the entry into application of the GDPR. So that's what you find in these reports. What are the issues? So of course we have to further process these reports. We hope to publish them perhaps on the AEGLE website, I don't know, or the Timelex website, but they will be available, sorry? You will, yeah, okay, right. So they will be public, of course, but we will also process them and in our final deliverable for AEGLE. So one of the first, of course, challenges is that using health data or reusing health data is not entirely regulated by the GDPR, of course. The legal framework is much more complex. The GDPR is only one layer. It's just like when you organize this conference, the organizers process personal data, but organizing a conference involves much more rules, university rules and other rules. It's the same for using and reusing health data for research purposes. It's only, for instance, if you look at the UK and you ask a researcher which are the rules you have to respect in the UK, you will be automatically referred to the very detailed procedures which need to be followed in the context of the NHS. The NHS Digital has published these rules. They have their own procedures. They publish every month this very long Excel sheet with all the institutions that have received access to the NHS health data for research purposes and other purposes as well. So the GDPR could not really harmonize the rules entirely. That is impossible. If the ambition was to harmonize something, it could be one layer of the whole legal framework. So that's one issue. A second issue is that, and that is also today one of the important issues for us, because the AEGLE action stops in the summer, but only few EU member states are ready with their national implementation of the GDPR. So many of our correspondents, they tell us that it is not yet sure what the rules will be next year, for instance, or even at the end of this year. So, for instance, a few days ago, the Polish bill was adopted in the first chamber. It has still to go to the second chamber and then signed by the president. And so it will take a few months before the Polish GDPR implementing the new data protection law will enter into force. Mahou told me yesterday that French law has been adopted in the French parliament last week, I think, isn't it? And so the Belgian law is not yet in the parliament. It's still, we are still waiting for the opinion of the Council of State, and it still needs to go to the parliament. And even in countries where the GDPR has been implemented into a new data protection law at the highest level, like in Germany and Austria, there is still a lot of work to do because, for instance, in Austria, they are working on a redraft of the research law. Let's say it's a specific law on using data in a research context. And there is an initial bill, but probably there will be discussions for several months, and certainly not before next year, and the legal framework will be finalized. Also, an issue is that the new rules, the new European rules, the GDPR, and the national legal rules on data protection, they have to be inserted into larger legal frameworks applicable to health research. You have to take into account not only personal data protection, but also, for instance, legislation on clinical trials, legislation on patient rights, legislation on perhaps medical devices, on drugs, on In some countries, even laws related to public archives are relevant, or laws in Germany, they have a church law, Kirchengesetz, which can also be relevant because some hospitals are subject to these specific laws. You also have to take into account that in countries like Germany, when you are, for instance, when you want data from a public hospital, the public sector is not regulated by the federal data protection law, but by the regional data protection laws. Germany has 16 Länder, so the rules are different in Niedersachsen or in Hamburg or in Baden-Württemberg or Baden-Württemberg or Bayern. So there are at least 50 different, also in the UK, with the devolution, the rules are different. In Scotland, in Northern Ireland, in England, etc. And so this is what I mean with the multi-layered legal framework. And then another issue is that when you ask what are the rules, in most of the countries, if you have to follow a certain procedure before getting the data, there are 2 steps. And only the second step relates to data protection, let's say, are there really legal rules. The first step is that you need approval from, I lost my microphone. Okay. The first step is usually that you need to go to some committee, an ethical committee in a hospital or a national committee, which has to give an opinion on, for instance, the quality of your research, the need to do your research, the ethical aspects, why do you need this personal data to do this particular research, etc., which are not legal questions, but questions that cannot be answered by a data protection lawyer or by a DPA, a data protection supervisory authority. And only the next step relates to personal data protection. What are the rules to use personal data? What are the rights of the data subjects, etc., etc. Very often there is confusion because especially ethical committees, and especially where they are regional or fragmented in some countries, like formerly in Sweden now they are bringing it together. In the UK it's already very well organized, but in Slovakia, for instance, it's very decentralized. So very often these ethical committees, they confuse law and ethics. So they go into legal considerations. They start to interpret the data protection legislation. And of course, the GDPR, when the data protection supervisory authorities interpret the GDPR differently, the GDPR provides for what we call a consistency mechanism, so in order to have the same interpretation everywhere. But for these ethical committees, this doesn't exist. And so to a large extent, diversity will continue unless we manage to bring these ethical committees more or less on the same line. First at the national level, and then hopefully further away on the European level. The GDPR is only, I have to go a little bit further. This is more a technical question, but new legislation obviously leads to different interpretations. In our law firm, we have continuously discussions on practically every provision of the GDPR. So it's a very complex text. You have to be very familiar with the directive to interpret most of the provisions of the GDPR correctly. And so this is just one example where we see that even in the implementations of the member states, there is confusion. There is a lot of confusion, and the implementations in the member states are not, of course, it's not possible systematically monitored by at the European level, and so member states go in two different directions, and that also is, let's say, one of the difficulties. The GDPR has also several backdoors. Member states tend to claim more autonomy at the national level automatically. So systematically they go into the GDPR and they look for possibilities to do it their own way, instead of taking the floor and asking the European Commission, oh, should we implement this? They simply do it their own way. And the GDPR leaves some margin to do that. That's normal in a complex text like the GDPR, which is in fact a compromise. So for instance, for reusing health data for research purposes, the idea in 2012 of the European Commission was we will have the basic principles in the GDPR, and then the Commission will enact, delegated act they call it, a set of rules for the European level, harmonized set of rules for the whole Union. But this was not accepted by the member states, so this further implementation is largely done nowadays at the national level. But in the end, one of the conclusions is that in some countries the GDPR will make things slightly easier. If it's still not our final conclusion, but reading all these reports, we think that in many countries, not in many countries, I cannot say that, it's probably a few countries, things will be slightly easier. There are examples where you can find examples where it becomes easier, like for instance in Denmark, you have to go to the DPA, the Data Protection Authority, for in fewer cases than before, to simplify things. Or in Austria, it's also interesting, it's not the consequence directly of the GDPR, but because the GDPR forces them to revise the rules, they now are drafting a system whereby the data will be collected at a national level in a kind of national database and then made available to all the researchers. And so they create a central research database. So that it's an indirect consequence of the GDPR. Of course, the simplification only on the rules applicable to this matter. One of our conclusions, preliminary conclusions, I must say, is also that the impact of the GDPR on what we are talking about today is much less important than you may think. It's the impact is not so drastic. It's in Belgium, for instance, the old provisions are simply copied and pasted into the bill implementing the GDPR. It's legally not correct, but it's again a case whereby a member state does it in its own way, and there are no real sanctions at this moment to prevent a member state to do so. In Estonia, also the current bill doesn't substantially modify the existing rules, but in Estonia, rules were also more or less what we now have under the GDPR. So it was not really necessary to modify many things in Estonia. Some preliminary conclusions then. Of course, the conclusion is that there is no such thing as a European legal framework for big data analytics in the health sector. That's evident. You have to go to the national and regional level to answer the question for every case. For lawyers, that's perfect. You always will need a lawyer if you want to be legally correct in this matter. So the things are much too complex and divergent to give you one answer. Legal provisions are also spread over many legislative instruments. You should not think that looking into the GDPR will suffice. You need to take into account the large number of different laws. I mentioned them already. Laws on patient rights, laws on clinical trials, and archive laws, laws on access to public information, for instance, also even. It was mentioned by John yesterday. The GDPR will only have marginal impact on the current legal complexity to be challenged in a European-wide. It sounds perhaps a little bit negative, but it is not really negative. It's simply because probably we have been too naive in the beginning. The research made us a little bit more realistic. The GDPR obviously has an impact on one layer, personal data protection in this context. But of course, it could never be the ambition of the GDPR to change all the other layers with which you need to take into account, which you need to consider if you, as a researcher, need health data for your research purposes. Okay, I think that's